Good morning and welcome to another edition of the Senate Committee on Commerce and Labor. Madam Secretary, please call the roll.
Senator Buck? Senator Daley? Senator Hammond? Senator Lang? Senator Pizzina? Senator Scheibel? Senator Stone? Chair Spearman.
Here. And I will apologize to you all. Your time is important, but I had a scheduled interview at 7:30 that I didn't see on my calendar, and so I was trying to do both. And I haven't perfected cloning yet, so please forgive me. Okay. So today we've got 3 bill hearings, and I want to take care of a couple of housekeeping items. Number one, make sure you're looking at your phones, make sure that they're on silent or off so that they don't interrupt the meeting this morning. Welcome to those who are here in Carson City, and I think I see one person in Las Vegas. And forgive me, my glasses are dark, and I don't want to look like I'm, cool, so I got them off until they lighten up some. So welcome to you and anyone who's listening to us on the internet or telephonically. Those are several of the ways that you can participate in this meeting. So all of the exhibits I think are already in, and just want to give another reminder to people who are testifying that it is unlawful for anyone to provide any testimony that they know is false, knowingly that is false. And if you do, then that is a misdemeanor. Any member of the committee can ask for documentation. I can ask for documentation. And finally, again, please turn your phones off or put them on mute. And with that, we will start our first, that might be Margie down south. We'll start our first bill hearing, Assembly Bill 22. The measure revises provisions governing the issuance of cease and desist orders for unlicensed activity by the State Contractors Board. Please begin when you're ready.
Good morning, Chair Spearman and members of the committee. My name is Margie Green, that's M-A-R-G-I-G-R-E-I-N, and I'm the Executive Officer for the Nevada State Contractors Board. I have with me today Dave Bihar, who is our Director of Investigations, I will turn this over to at the end of my presentation if time allows. I'm here today to testify in support of Assembly Bill 22, which clarifies the process the board must adhere to when issuing cease and desist orders pursuant to NRS 624212. Under existing law, the board shall issue a cease and desist order to any person acting as a contractor or submitting a bid in Nevada without a valid contractor's license. These orders are issued to unlicensed contractors only and are written specific to the person committing the illegal activity, the activity itself, and the location of the activity. Current law segregates the authoritative actions of the board following issuance of a cease and desist order based on the board's determination of a contractor's compliance. The proposed language in AB 22 continues this authority, but in a more direct manner, which we feel will help streamline the process and better clarify potential options to address unlicensed activity. Under the single procedure set forth in this bill, after a cease and desist order is issued, the board shall issue an administrative citation for the first offense, which does not involve theft or fraud. When it is a second or subsequent violation, the board shall issue an administrative citation or report the violation for possible criminal prosecution pursuant to NRS 624700. Following issuance of a cease and desist order, AB 22 retains the existing authority of the board to consider requiring the person to submit an application for a contractor's license, or if the person is not compliant with the order, the board is to apply for injunctive relief through Nevada Rules of Civil Procedure. This bill eliminates distinctions in existing statutory procedures that are based on the number of previous violations and the value of the unlicensed work. To help set the context of the pervasiveness of this issue, the board has issued 924 cease and desist orders over the past 3 years, of which 90% were for unlawful construction work that was either abandoned or completed with workmanship concerns noted and reported by the homeowner. All persons who have received the order complied and were issued an administrative citation or had their cases filed with the District Attorney's Office for criminal prosecution pursuant to NRS 624700. Regarding the issuance of administrative citations and the total fines and investigative fees paid as a result, there is a stark contrast between the compliance of licensed contractors versus unlicensed contractors. From fiscal year 2019-20 through March 27, 2023, the average administrative citation fine and costs totaled roughly $347,000 per year, with approximately 77% of licensed contractors complying with payments. During the same period, the average administrative citation fine and cost against unlicensed contractors totaled approximately $617,500 per year, with only 29% of the individuals complying with payments. I would also like to note that there have been several large commercial construction projects in Nevada where unlicensed contractors were utilized as subcontractors. Once the board was advised of the unlicensed activity, the board took appropriate action in the issuance of a cease and desist order to the unlicensed contractors, while also issuing a citation to the general contractor for contracting with an unlicensed contractor. Again, I would like to make it clear that AB 22 simply realigns the existing authority of the board under NRS 624212 to provide a single procedure subsequent to the issuance of a cease and desist order that is consistent with our authority under NRS 624700 and 624710. We have worked with the Nevada District Attorneys Association and the Assembly to amend the bill with their recommendations. And at this time, I would like to turn it over to Dave Behar, our Director of Investigations.
Good morning, Chair Spearman and members of the committee. My name is Dave Behar. I'm the Director of Investigations for the Nevada State Contractors Board. I'm here today to provide testimony in support of Assembly Bill 22, which again outlines the process the board must adhere to when using an administrative citation. As an agency entrusted with the responsibility of protecting the health, safety, and welfare of the public, I wish to highlight several examples of why the board is seeking to include language that allows for prosecution of first-time offenders. In December of 2022, the board received a first-time offense complaint against an unlicensed contractor for abandoning a project involving two seniors who were ridden with a variety of significant health issues that included dementia, strokes, and the use of an oxygen tank due to severity of respiratory matters. During this investigation, it was learned that this unlicensed contractor received approximately $14,000 in funds from these homeowners for the removal and abatement of mold at their residence in April of 2022. During the initial abatement process, this unlicensed contractor conducted extensive demolition throughout the property and alleged that they had uncovered the location of leaks throughout the residence. As a result, this unlicensed contractor conspired with a licensed plumber to help complete this work. Shortly thereafter, this company conducted additional demolition work at the location, resulting in the residence becoming completely infested by rats and ultimately uninhabitable. In addition to the money paid to the original unlicensed contractor, these homeowners were then forced to pay an additional $12,000 in hopes of having their residence repaired. Sadly, once this payment had been received, the project was completely abandoned, and the two senior homeowners were forced to move into a small casita in the rear of their property, to include not having the use of running water. A second example I would like to bring to your attention also involved a first-time offense committed by an unlicensed contractor who entered into a written agreement with a disabled homeowner in January of 2022. In this particular instance, the homeowner paid over $235,000 to the unlicensed contractor for work that included plumbing, electrical, gas, cabinetry, painting, drywall, flooring, framing, and wall coverings. During the course of this investigation, it was learned that the unlicensed contractor significantly damaged the interior of this homeowner's residence. This included the destruction of a stairwell in their house and a safety barrier of a single-person elevator that was being used by the resident's occupant to move between floors of the home because they were an amputee. Due to the fact this project was ultimately abandoned, this disabled homeowner was forced to retain a third-party group to assist her with repairs that totaled close to $500,000 to make their property habitable again. The board looks forward to continue working with the Nevada District Attorneys Association and other concerned parties regarding AB 22. And I want to thank you for your consideration and time, and would be happy to answer any questions if you might have any. Thank you.
Thank you. Committee members, questions? Senator Daley, and then Senator Pazina.
Thank you, Madam Chair. And Ms. Green, or Director, I guess. So can you explain a little further on what is not working in the process that we had that came from 2019? And then I have a follow-up question as well after. I just want to understand a little bit better why it's not working. I know you mentioned that before when we talked. And if we can streamline it a little bit, that's fine. I just have a couple of other questions after you answer that question.
Thank you. And Chair Spearman, may I go directly to Senator Daley?
Please do, please do.
Thank you. Thank you, Senator Daley, for the question. As noted, a lot of times an administrative fine through a citation is not enough of a deterrent for some of these folks. They're not paying the fine. We can turn it over for collection, but without having that the ability to turn it over to the district attorney for prosecution, some of these unlicensed individuals are simply getting away with continued fraud against elders and seniors and our vulnerable communities without having any kind of record. We feel having the ability to, in cases involving theft or fraud, being able to go directly to the district attorney with these cases would serve as more of a deterrent than an administrative fine that in most cases they don't pay anyway.
And thank you. And I agree with you that we should prosecute to the fullest extent as we were trying to get things done in 2019. The second question that I got is, we had language from before that if they didn't comply, and I know we set a threshold of 50,000 and under and above 50,000. But the person wouldn't be able to allow to complete the work. And I don't see that language in the amendment or in the new draft. And as I recall, and you can help refresh my memory, you said that a lot of times these people, they get the cease and desist order, maybe they can make some corrections and various things. But in some cases, not the examples you guys gave, the homeowner's out, they've already made a bid, what do they got to do? The project's half done. They can't hold up waiting to get another contractor and various things. So that's why we had that 50,000 number, if I recall correctly. But if it was above that, and maybe we need to put something in, if it's a commercial situation, not a residential, that contractor can't complete the work. He's done off the job and can't go back. And I don't see that in the current revisions.
Thank you, Senator Daley. Margie Green for the record. I believe we still have that authority under our administrative regulations to put a steeper penalty for projects in excess of, I'd have to look that number up. I thought it was 500,000. We do not allow the contractor to go back, an unlicensed individual, to go back and complete any work, regardless if it's residential or commercial. I don't believe that the current changes in the bill would have any effect on that, but I could ask Dave Beathard to expound on that a little bit if you'd like.
Sure.
Thank you.
David Beathard for the record. Currently, the administrative citation amounts are from 1,000 to 50,000. With regards to commercial projects, if that's the type of language that we might want to consider, that would be something we would look at.
And thank you. And it is in some of the language that that's being struck out from this time from the previous language where they said if they didn't comply with the cease and desist order, other than safetying the job up, they wouldn't be able to complete the work. And the main concern, and I understand 80%, probably more of your complaints are on residential construction and smaller projects. But on the commercial side, these people know what they're doing and they weren't mistakes and they should not be able to benefit from that in any shape or form. Final question though, when you were doing your testimony, you said that this applies to unlicensed contractors only. So I'd like a little better explanation of that. Maybe we need to change this stuff. So if someone's unlicensed completely, has no license, that's one thing. That's pretty clear. They're unlicensed. They don't have. But if a contractor is licensed but outside their scope, or licensed but over their limit, is that considered unlicensed in the context of this? And do we need to clarify that a little bit more? Because a contractor can be performing work outside of his scope, technically still be licensed for concrete and C5, but doing plumbing work, right? So they would be unlicensed for the plumbing work. Does that need to be clarified if you have a license technically but are outside your scope or over your limit?
Thank you, Senator Daley. Margie Green for the record. I'm sorry if my testimony wasn't clear on that. Under 624.212, it states that we shall issue a cease and desist to any person acting as a contractor without limitation, commencing work as a contractor, submitting a bid situated in the state without a valid license issued. And it goes on to state that that they have to have an active license. I believe there have been cases where we can issue a cease and desist to a licensed contractor if they are outside of their scope. I don't know how often we have done that, but I think the statute referring to is 64212.1, and I'm happy to look at that further and give you a more definitive answer on that.
Yes, if we can look at those two things about not being able to continue
Certainly.
work and when you can do this outside scope and about the license, I'd appreciate it. Thank you.
Thank you. Senator
Thank
Pezzino?
you.
Thank you so much, Senator Daley. Actually, his first question was what I was going to ask, so thank you. I'm good.
Thank you. Senator Scheibel?
Thank you. You did mention it in your presentation. I just missed it. Can you give us a little bit of an idea of the scope? How many people you're currently sending cease and desists to? How many of those turn into open cases? How many are referred to the district attorney's office?
I believe Mr. Bihar has this, Margie Green for the record. I believe Mr. Bihar has the information on that. I referred to the number who were issued cease and desist, and I don't know if we have something further on that.
Good morning again, David Bihar for the record. Between 2019 and 2022, there was a total of 1,636 cease and desist orders.
And that's statewide?
Yes.
All right, thank you.
Senator Stone?
Thank you, and good morning, Chair. Thank you for the presentation. I see that this is going after people that are doing work without being licensed. What kind of educational campaign have you been undertaking to protect the consumers from some of these nefarious people that are taking advantage of them? And then I noticed that I think the presenter said that one of the minimum fines was $1,000. Should there not be a higher fine for those that knowingly are participating in work that they know that they are not licensed to do? I just worry about the consumer, especially the elderly. do they really know what to ask for and seeing a license? And is it possible that a licensee or an alleged licensee could be showing a false license to kind of defraud the person that's contracting with the unlicensed contractor?
Thank you, Senator. Margie Green, for the record. Your first question concerned what are we doing to educate the consumers. We have an extensive public relations or public education program with the board. However, it's really difficult. That's an ongoing battle we face all the time. We make ourselves present at different home shows, at senior events. We have town hall meetings. We have information on our website. We're currently doing a variety of ads on TV that we're going to pick up again to educate consumers. We distribute flyers and brochures at different senior events. It's an ongoing effort and battle that we have faced because, of course, the population is so transient. A lot of people don't even realize a contractor's license is required. So we're continuing our efforts and outreach. We work with the associations and hold a variety of events to educate consumers on the dangers of hiring unlicensed contractors. And again, we can't do enough, and we're continuing to move the needle so that we reach as many people as possible. And excuse me for getting your second question. I believe it was regarding the fines and penalties.
Yes.
It depends on the violation. They range anywhere from $1,000 to $50,000 for the first offense. And there's a variety of what type of work that would include. Of course, in the situations that Mr. Bihar referenced in his presentation, we went after the maximum fine on those. And again, in some of the cases that Mr. Daly referenced or that we worked with him on before, again, it would be the maximum penalty. So there's some distinction between first offense on maybe someone is doing something small, maybe a painting job that's only $1,500, so the fine would be in accordance. And if they're a first-time offender versus a repeat offender, or if there's crimes involving the elderly or the vulnerable, we would go after the higher penalty on those. And did I answer your questions accordingly?
Yes, and I really appreciate it. If I can just follow up a little bit with you. It just seems to me that a $1,000 fine is de minimis, that they could just kind of say, well, you know what, I got 5 jobs going on right now, and $1,000 is not going to stop me, even if they come back at a second swipe at me for $1,000. I would say that I would hope that maybe you would consider a $5,000 minimum fine so we have a stick out there to protect these vulnerable populations. That's certainly something that the committee can discuss. And I appreciate your educational campaign. I know it's tough, but I'd recommend a couple things. There's a lot of senior-only communities in certainly southern Nevada where I reside. Maybe a fact sheet that can be given to a homeowners association that can be passed on to their members, showing the dangers that can happen if they don't really check the contractor out to make sure that they're licensed and qualified to be able to do some of these jobs. Especially, I heard a horrible situation where a person was installing a air conditioner, and the person that hired the air conditioning alleged contractor thought he was licensed, and he wasn't licensed. And then an hour after he finished putting in the unit, it caused a fire that almost destroyed the entire home. So, of course, that's probably involving your agency and litigation, but some of these contractors can really cause some devastation, including the death of a homeowner. So hope that you'll reconsider those minimum fines and expanding those educational campaigns to these senior-only communities. And I appreciate your presentation today. Thank you.
Senator Buck?
Thank you, Senator. Very good points, and we will continue to increase our efforts on that. Thank you.
Thank
sorry,
you, Chair
Senator
Spearman. I agree with my colleague. $1,000 seems minimal when you defrauded someone for $14,000. Is there a platform where you list these bad actors so people are aware of the ones that are habitual offenders?
Thank you, Senator Margie Green, for the record. Yes, we do keep a list on our website of our most wanted, I guess you would call them. A lot of times we have to wait for the process to play out before we have a final order or final citation before we can list them. But yes, it's an ongoing effort to educate consumers of who to look out for. And a lot of times they use, they may think they're hiring a licensed contractor because that person gives them a business license number. So we're constantly trying to educate them that a business license is not a contractor's license. And again, appreciate all your efforts to understand this problem that we're trying to address.
And is there a number that you can call to verify someone especially for the elderly?
Thank you, Senator Margie Green, for the record. Yes, we have a hotline, a fraud hotline for unlicensed contractors. And we also encourage people to look up if their contractor's licensed. We have a mobile application and a lot of times seniors don't use those sort of things, but we encourage them to always call and verify that the contractor that they're hiring or getting a bid from is in fact licensed. But there is a hotline number.
Thank you. So I just have a couple of questions, and I'll start with another incident that I know of where a contractor showed what appeared to be contractor's board license, and homeowner gave the person $19,000. They were supposed to take out a tub and install a shower. They started the 1st of May, and by the middle of October, still weren't finished. So here's my question. How do you know if no one tells you that there's an unlicensed contractor working? And maybe this is a Ouija board question, but I'm just trying to figure out if there are ways that we can figure out how to catch them before someone is harmed. But I don't know what that looks like.
David Behar for the record. One of the easiest ways we try to suggest doing that is to use our website. And understand for some it's easier to access that than others. But we're happy to talk to people on the phone and walk them through that, or if they have a question, we'll check it on their behalf oftentimes. And it's a very simple approach to click on our website and do a license search, and you're able to conduct that search by company name, by the contractor's name, by the license number itself. And that will pull up their information, and that can immediately verify whether or not they're a licensed contractor, if complaints had been filed against them, a variety of information that is instantaneous on the internet that anybody could pull up pretty easily on a mobile app or on a computer. And those that don't have access to that or might have difficulty navigating that, we always encourage them to contact us directly, and we'd be happy to always do that on their behalf if it requires that.
Thank you. Next question. Are you all involved at all collaborating with the AG's office? I think they have an expanded role now for consumer protection.
David Behar for the record. That's very accurate. We've recently created a task force where we're working with the Attorney General's office and other partner agencies, and our efforts are focused on this unlicensed contracting to try to be a force multiplier to go after them in a variety of different ways, some of which have been just talked about, conducting public service announcements, workshops on behalf of both the industry and the community to kind of bring everybody together to get a better understanding of those efforts. And the Attorney General's office will also be working with us in the future to help go after unlicensed contractors when it's deemed appropriate.
Last question, I think, and then I'm just going to comment on what my colleague said. Okay. In terms of the PSAs or how do you get the word out, I don't know what it's like here, but I know in Southern Nevada you can walk through just about any neighborhood casino after 1 o'clock and see the bingo room filled with seniors basically. And so if there were a way to work with the gaming industry to, put that information out, that might be another way. Another way could be with the HOAs, make sure that they are putting that out at every meeting or every other meeting or with some level of frequency. And last, the enhanced penalty, and maybe that takes in, that accounts for the question about de minimis. And I think the law says if they're 62 and older, there's an enhanced penalty. And so perhaps that $5,000 can be appropriated to whatever that enhanced penalty is. But certainly, someone who causes a fire, for someone who is a senior and trusting them with their home, there's probably a special place for them in the South, and I'm not talking about South America. Senator Scheibel.
I just want to commend you because I checked while we were doing this. I just Googled Nevada contractor license and it took me directly to your website. I was able to search by name, confirm that if anybody named Melanie Scheibel tried to offer me services, she's not licensed, but someone named Ira Hansen absolutely is. So, it was easy enough just with first and last names to find that information. So I agree. It is really easy to search. And if we can get more people to understand that and do that before they hire somebody, I think that would be great. So good job.
Senator Stone.
Yeah, just one more follow-up, if you don't mind. So a licensed contractor that knowingly contracts with a unlicensed subcontractor, that to me is pretty egregious, where a would-be client would just trust the contractor to think that anybody who's working for him is also licensed. So are there any enhanced penalties for those that knowingly hire unlicensed subs to the detriment of those clients?
Thank you, Senator Margie Green, for the record. Yes, there are. Of course, the biggest penalty we can put on a licensed contractor is revocation of their license. And a lot of times, if they care about their license, they're going to try to comply with the laws. But we have a lot more tools we can use against licensed contractors who violate the law than we do against unlicensed.
Agreed. Thank you.
Thank you for your comment.
Thank you. Ms. Green, any additional presenters?
No, Senator.
Okay. So with that, let's open up public testimony in support of Assembly Bill 22. Here, see people coming to the table. Don't see anyone in Las Vegas. Let's start up here in Carson City. Yes, sir.
Thank you, Chair Spearman, members of the Senate Commerce and Labor Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association in support of AB 22. I want to thank the Nevada Contractors Board for working with us on our concerns on the Assembly side. We are in a position of support now with the amendment. And I want to say I do appreciate back in 2019, I know Senator Daley was a leader in the effort to kind of beef up the administrative citation process with respect to unlicensed contractors, while still leaving the criminal system to address a certain behavior as well. I think this continues that effort to the extent we need to enhance the administrative citation process, enhance the enforcement mechanisms. We are more than willing to work with the Contractors Board to focus on that. But looking at specifically what conduct should be charged criminally, that's when we're talking about the fraud. Somebody who is holding themselves out to be a licensed contractor and then inducing somebody to sign a contract with them when in fact they're not licensed. Or somebody who accepts $10,000 as a down payment on a contract and performs no work and provides no refund. That's a situation involving theft where the criminal justice system should be involved. So again, I want to thank you, Chair, for hearing the bill, and I want to thank the Contractors Board for working with us.
Thank you. Senator Daley, for the third time.
I'll be quick. So I was looking at the language from before and now, and in your mind, what is the difference? I know before that if they didn't follow the cease and desist order, that it would report it to the district attorney or whoever it was. And now it says that they can go they can continue with an administrative citation even on the second one, or send it to you guys. So where do you see the difference there, and why couldn't you prosecute, or why wasn't some of it prosecuted, or did you only take up some of the cases?
John Jones on behalf of the Nevada District Attorneys Association. My understanding, Senator, that there was some confusion about whether or not on a first-time violation that the case could be submitted to us if there are evidences of fraud or theft. I think this clarifies that in that instance, you can submit to us on a first-time violation even when those indicators are present. The second point is there may be a situation where somebody comes before the board with a second unlicensed activity that the board feels that the administrative process is sufficient to punish or curb that behavior. And I don't want to tie the board's hand in that situation either. So I want to give them as much flexibility as they need to handle this unlicensed conduct.
Thank you.
Good morning, Chair Spearman. Chase Whittemore, Argentum Partners, representing Nevada Builders Alliance. And we support this bill. We supported it in the Assembly. We support this as redrafted. Unfortunately, there are some bad actors in the construction industry. And I think this bill adds some clarity to the procedures and gives proper tools to the Contractors Board to go after those small number of bad actors. Yeah, we're open for any questions if you have any. Thanks.
Good morning, Chair and members of the committee. My name is Michaela Rezai, spelled Mikaelarezaei. On behalf of McDonald Carano, representing Nevada Home Builders Association, Southern Nevada Home Builders Association, and Builders Association of Northern Nevada. We support this bill because, unfortunately, there are bad actors in the industry, and we support giving the NSCB more authority to go after those bad actors. Thank you.
Thank you. Anyone else here in Carson City? Support? BPS, anyone on the phone lines?
If you would like to testify in support of AB 22, please press star 9 now to take your place in the queue. Public line is open and working. There are no callers at this time.
Thank you. We'll move now to those in opposition. Opposition here in Carson City. I don't see any come to the phones or to the chairs. Anyone in Las Vegas? No one there. BPS, anyone on the phones?
If you would like to testify in opposition to AB 22, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you. We'll move now to those who are neutral. Anyone here in Carson City? No one's coming to the table. No one in Las Vegas. BPS, anyone on the phone lines?
If you would like to testify in neutral for AB 22, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you. With that, we'll close public testimony. Ms. Green, any closing comments?
Thank you, Margie Green, for the record. And I would like to thank the committee and you, Chair Spearman, for hearing our bill today and continuing our effort to increase protection of the public. Thank you.
Thank you. And with that, we will close the hearing on Assembly Bill 22. And I see Assemblywoman Brown May here, so I'm going to go to your bill. It's Assembly Bill 78. Welcome, and begin when you're ready.
Thank you, Chair, distinguished senators of this committee. It is my honor to be able to be here today to present to you. For the record, my name is Tracy Brown May. I'm the Assemblywoman that represents Assembly District 42 in Clark County. This is my first bill presentation in the Senate this session, so thank you for being number one. Assembly Bill 78 exempts certain providers of jobs and day training services from licensure as nurses, which is why it's here in front of you today. I'd like to start by talking a little bit about my background. And so for many of you, you are already aware that I've spent the last 20 years in disability advocacy and disability support services, working for a jobs and day training organization. And in that capacity, have learned a lot about some of the intricacies and barriers that people with disabilities experience when accessing community. This bill is meant to address one of those barriers by eliminating it. So, nearly 1 in 4 Americans are currently living with a disability, and for too long, people with disabilities have been denied equitable access to social, educational, and professional opportunities. Community integration provides an opportunity for people with disabilities to achieve an overall healthier life and well-being. Jobs and day training services are essential as an asset in assisting people with disabilities to access and obtain meaningful skills and life employment. Certain JDT services are currently restricted due to existing law that requires staff to be licensed by the State Board of Nursing to administer medication to individuals who may require it while participating in these programs. The change in this law eliminates that restriction and allows jobs and day training providers the opportunity to train their staff in medication administration, which then helps people gain access to community. I'll give you a scenario. You are a person with a profound disability. You have epilepsy. You require medication to be administered throughout the course of the day, or seizures. And so your team of people are going to go to the movies or to bowling or to shopping or to volunteer activity at 10 o'clock in the morning, and your medication is required at noon. You won't be back before 1:30. The nurse that's on staff at the provider organization is not going with you, so you can't go because your medication needs to be administered during the time that the group of people are scheduled to be out in a community setting. And so you can't go. By allowing jobs and day training providers to be able to certify their staff in medication administration, that person, that direct support professional that's going with you, can administer your medication for you while you're out in a community setting. It's really that easy. This provision is already existing in Nevada revised statutes for supported living arrangement providers and has been there for a number of years. I do have in the audience here a Deputy Administrator with the Aging and Disability Services Division, Jessica Adams, who has worked very closely with me on this provision. It really brings parity between the provider organizations that serve people in their living arrangements and provider organizations that serve people in their day activities, so that you don't have to see a medical professional in order to get your medication. You can instead receive your medication by a certified agency direct support professional. That is the entire bill. I'm happy to stand for questions.
Thank you. Committee, Senator Scheibel.
Thank you so much, Assemblywoman, and I think you may be the first Assembly person to present in the Senate at all this session, so, or since the deadline. Anyway, I like this bill. It sounds like common sense to me, and I just want to confirm my understanding that for that person who you mentioned wants to go with their community to lunch, to a movie, something like that, if they had a person, like a parent or a sibling who was able to go with them, there's nothing in the law currently preventing that person from carrying their sibling or whoever, the person's medication with them and administering it. It's just because the day training facility type people are professionals and they have that professional relationship with the person with the disability that they're prevented from doing something that a friend, family member, other person would be able to do.
Thank you. Tracy Brown May for the record. Senator, I appreciate that question sincerely, and through you, Chair, to the Senator Scheibel.
Go direct.
Thank you, ma'am. That is exactly the case. Because jobs and day training providers are certified and licensed, they're regulated by the Division of Aging and Disability Services. The staff working at each of those agencies must comply with a number of training provisions. There are things that JDT providers have to do in order to maintain compliance and certification to provide services through the state. This is one of the provisions that currently doesn't exist, so there's no way for us to do that without fixing the NRS that specifically states we can train professionals and you don't have to be a nurse in order to do that. But familially, in your family, if you have your parent or another person, they could provide your medication as there's no contractual relationship there.
just to follow up, so basically what I wanted to clarify is that if this person were not in that professional relationship with the person with a disability, it's not like this would otherwise be illegal or unlawful or wrong. That, you know, a person with a disability can, and often people do, have someone who comes with them places that may carry their medication, help administer it to them, keep track of time, put an alarm on their clock, and that there's nothing wrong with that or illegal about that. It's only because they share this professional relationship that a barrier is erected to prevent a person from doing that.
Tracy Brown Ray, for the record. Thank you, Senator. That is correct. That is my understanding. Yes.
Additional questions? Okay. Any other presenters? Okay. So if you'll step back, with that, we will open public testimony on Assembly Bill 78. Anyone here in Las Vegas in support, please come to the table. In Las Vegas in support, come to the table. BPS, anyone on the phones? Are you in support?
If you would like to testify in support of AB 78, please press star 9 now to take your place in the queue.
Thank you, Madam Chair and
Oh,
members.
just a minute, we're on the phones right now. I'm sorry.
My
It's
apologies.
okay, it's okay.
Caller, go ahead and press star 6 to unmute.
Good morning, Madam Chair and members of the committee. Stephen Cohen for the record. Stephen with a V. Cohen as in the Assemblywoman, no known relation. Ditto. Thank you, and I yield.
Good morning, awesome senators and Madam Chair Spearman. This is Dora Martinez, and I ditto the dittoer. Thank you so much for the sponsor, Tracy Brown May. Thank you. Have a great day.
There are no callers choosing to testify at this time.
Thank you. Back up here in Carson City in support.
Thank you, Madam Chair and members of the committee. For the record, my name is Mary Przenski, and I'm here representing SNAP, the State of Nevada Association of Providers. SNAP members partner with the Aging and Disability Services here in the state, and they carry out programs such as the supported living arrangements and also the jobs and day training. The programs are obviously for intellectually and developmentally disabled Nevadans, and SNAP serves almost 80% of those Nevadans in our state who are disabled. SNAP is in strong support of AB 78. The supporting living arrangement staff are allowed to distribute medications once they are trained, and the jobs and day training people currently cannot do that. They need more flexibility. It will be helpful for those who are in jobs and day training to be able to participate in more activities. And so we're asking for that same flexibility for the JDT people. And SNAP is in strong support of AB 78. Thank you.
Thank you. We'll move now to those in opposition. Here in Carson City, Las Vegas, don't see anyone. BPS, anyone on the phones?
If you would like to testify in opposition to AB 78, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you. We'll move now to those in neutral. Anyone here neutral? Carson City, Las Vegas, don't see anyone. BPS, anyone on the phones?
If you would like to testify in neutral to AB 78, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Okay, thank you. Assemblywoman, closing comments?
Tracy Brown May for the record. I just want to offer my sincere thanks for the opportunity to present this measure for your consideration. It really will help people gain access to community integration and just more equity in our society. So I thank you very much for this opportunity.
And thank you. And with that, we will close the hearing on Assembly Bill 78 and open the hearing on Assembly Bill 29. Begin when you're ready.
Thank you. Good morning, Chair Spearman and members of the committee. My name is Margie Green, that's M-A-R-G-I-G-R-E-I-N, and I'm the Executive Officer of the Nevada State Contractors Board. I'm here today to testify in support of Assembly Bill 29, which clarifies the language for disciplinary action against a licensed contractor. The board seeks to expand the language in NRS 6243016 by including a cause for disciplinary action against a licensee for making a false or misleading statement or representation or the omission of a material fact in connection with the application of another person. Since this experience validation process often relies on references or employment verification by other contractors, preserving the integrity of this process is important and is in the best interest of the industry and Nevada consumers. The proposed amendment will provide the board with an additional tool to deter activity related to falsification of experience documentation and reinforces and underscores the importance of each person's roles and obligations in the licensure process. Based on the discussion and testimony before the Assembly Commerce and Labor Committee, the bill was amended to clarify that the provisions apply only to statements provided by a licensee who is a natural person or an owner, managing member, or any persons who qualify on behalf of a licensee pursuant to subsection 2 of NRS 624260. And again with me, I have David Bihar, Director of Investigations, to provide further testimony. Thank you.
Good morning. David Bihar, Director of Investigations for the Nevada State Contractors Board. I'm also here today to provide testimony in support of Assembly Bill 29, which outlines the process the board utilizes to establish experience for a licensure applicant. Currently, our board utilizes several methods to verify the accuracy of experience submitted by a licensee, to include in-person and video conference interviews, and we document requests to confirm and vet the legitimacy of industry experience provided by references as they relate to specific work or projects. These methods of due diligence are obtained by members of the board's investigative unit as part of our current practice to corroborate the experience of a licensee. As part of this process, members of the board's investigative unit often encounter false or misleading information that's been provided by other owners of a license, managing officers of licenses, or other qualified individuals. When questioned by the board for further verification, oftentimes this information is unable to provide verification, or they don't provide supporting documentation to corroborate the alleged experience of the applicant's licensure. Examples of this have included projects in foreign countries, claims of documents being destroyed, and lack of payroll records that were used to authenticate hours and the scope of work that these contractors allegedly conducted on these various projects. Because our mission is to protect the health, safety, and welfare of the public, we feel AB 29 allows for these measures to be implemented to deter and prevent false or misleading information to be used when we're trying to corroborate the experience of these licensing applicants. Thank you again for your time and consideration, and we'd be happy to answer any questions you may have.
Thank you. Senator Pazina.
Thank you, Chair, and thank you so much for the presentation. I was just curious, how frequently have you found these false or misleading statements to be made on contractor applications?
David Bihar for the record. We do these experience checks. I wouldn't say it's that often, but when we do them, I would say, I don't have an exact percentage in front of me, but I would say it's very frequent that we come across that. only because they're trying to help this person become licensed, and oftentimes they might have a personal relationship with them. So it's our job to vet that process to help protect the safety of everybody involved. So I don't have an exact percentage in front of me, but I could report back to you with that if you'd like.
Thank you. Additional questions? Okay. Thank you. So we'll move now to public testimony in support of Assembly Bill 29. I'm going to do that often.
Good morning again. Chair Spearman, Chase Whittemore for the record, Argentum Partners representing Nevada Builders Alliance. We support this bill. Again, very similar testimony, another tool in the tool belt for the Contractors Board to go after bad actors. Thank you.
Good morning, Chair Spearman, members of the committee. Lindsay Knox with McDonald Corano, here representing the Southern Nevada Home Builders. Similar to Mr. Whittemore, we support this bill as it protects the integrity of the construction industry. Thank you.
Thank you. Anyone else in support? BPS, anyone on the phones?
If you would like to testify in support of AB 29, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Okay, we'll move now to opposition. In opposition here in Carson City, in Las Vegas. No one's moving, so BPS, anyone on the phones?
If you would like to testify in opposition to AB 29, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Okay, moving now to neutral. Carson City, Las Vegas, no one's moving. BPS, anyone on the phone lines?
Chair, your public line is open and working. There are no callers at this time.
Thank you. And so you want to come back up, Ms. Green, and close out Assembly Bill 29.
Margie Green for the record. Thank you, Chair Spearman and members of the committee for allowing us to present this bill to you today. We appreciate the efforts in our continuing goal to protect the public. Thank you very much.
Thank you. And with that, we'll close the hearing on Assembly Bill 29 and open it up now for public comment. Anyone here? Carson City, in Las Vegas? BPS, anyone on the phones for public comment?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Public line is open and working. There are no callers at this time.
Thank you. And committee members, no questions, no comments. So thank you all. And again, my apologies for making you wait. Appreciate that, and hopefully it won't happen again. You can withhold whatever chocolate I have in my office from me. All right, that's my punishment. So with that, we will adjourn the Senate Committee on Commerce and Labor, and we will see you back here at 8 o'clock on Wednesday. Thank you. We're adjourned.